Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey, folks, and welcome. Look, who joined me from the start. Hello, Mr. Jingles. Hello. 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 Hey! That doesn't happen all the time, that Mr. Jingles joins me from the very start. Hello. This is from the premiere I had earlier today. Satchel became a member. Indy Love became a member. Elizabeth Wright became a member. Thank you so much. And I was gifted a bunch as well. Hold on while I check. Dun, dun, dun. Oh. That's a lot. What happened? Joined 0 days ago. Is and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Almost 30 people. That's a lot. That's a lot. Thank you so much for the gifted memberships in the premiere earlier today. And becoming members, you now have, as you may know, but I will repeat it, access to all my members only emojis. You have access to all my members only content, which, for instance, the intro for the panel show later today is I showed it to members first, and they seem to like it, so it became an intro for the panel show. And I like to do that so I can get input from you guys, and specifically from members. So yeah. And of course, you also have access to my Discord. The Discord, I will be in there once or twice a week. The Discord is mainly for the members. So you can talk to each other, get to know each other, discuss and critique and all the things. All the things. And the topic I'm putting out after today is the planned so far. I'm not there yet. 10K celebration stream. It's planned for next Friday, but I have to get there first. We are currently at 9,930. We are 70 away. Only 70. And yeah, so the last month 2 months, I've been at around 200 new subscribers, I have to say, per week. So we should get there, but we aren't there yet. So far, next Friday panel show will also be a celebration stream for you guys, for me, for everybody who's around, and yeah, so it's really, really close. Really, really, really close. And yeah, so hopefully next Friday, I will, and this I talked about before, I believe. One of my personal project is a fundraiser for the Zachariah Anderson Appeals Fund. So that will be incorporated in the celebration stream. And I will start to have a couple of videos out about that case. Because when I covered it in March of last year, I had maybe 1,200 subscribers. And now I'm almost at 10K, which means 9,000 of you probably haven't heard much about it. So I will try to get you up to speed as well about why I believe Mr. Anderson is wrongfully convicted and high chance completely innocent. All right, but we are not here for that. We are here for the Young Thug trial. Now, have to start with where we left off yesterday, and which is, as you see, it's an hour and 40 minutes left. Yeah, most of it is silent. Most of it is really silent. So we will be good and done before the Friday panel show starts, and you will hopefully get redirected to that panel show. If you don't, I will have the link up everywhere, or you can just go to my page. Yay. And hello over at Rumble, by the way. Hello over at Rumble. Hello. All right, but we are here for the Young Thug trial. Recap of the last 24 hours, more or less. And the thumbnail says no love, which is because today Miss Love chose to not be there. Weird, isn't it? But let's go with the final yesterday. And I have to go fetch my nicotine pouches because, as per usual, I forgot about it.
Definitely.
Yes, sir.
Your Honor, while we have a minute, can I ask, can we go back to number 23 on page 6? It says Tyrone Dennis.
Yes.
The second check or second box thing says overall investigation of crimes of YSL between January 2015 and December 2015. I don't know what exactly the state means by that. Summary witnesses, my understanding, are frowned upon. Investigator Dennis previously, when Judge Glanville was the judge in this case, there was a easel with pages being flipped where he was listing all these different shootings and saying what was gang related, what wasn't gang related, or really just what was gang related, and kind of going through a timeline of a bunch of different acts of violence. I don't think at this point, if it's targeted to something, I'd be interested to know what the state is trying to get from Investigator Dennis at this point. But just like another recap of everything that was going on. I mean, we objected the first time, and we still don't believe it was appropriate. But to do that again, it's just we're kind of retreading the same summary of this case. And the jurors, they're smart, they get it. And so I just don't think that would be appropriate.
Okay, well, I'll inquire. I'm sure you're not going to just put him up for a recap of what he's already testified to. What's going to be new?
Your Honor, we're not putting him up through for a recap. What we gave on that sheet of paper was a generalization. If, as for instance, he was allowed to talk about his investigation. He was qualified as a gang expert in many of the incidents that he investigated. He was able to gain information pertaining to some of the facts that he testified about. Some of the things that he was able to testify about. He also actively, like I said, participated in the investigation. So he, as a fact witness, was able to testify about those things as well.
As I said yesterday, for me, it is incomprehensible. I don't understand how any court anywhere could have a person being both fact and expert witness. There are numerous gang experts all around the country, in the world. I mean, surely there are more than retired Atlanta PD cops that can be gang experts, which is evident because the defense got one, an actual gang expert. But having the same person testify both as a fact witness and an expert witness, more or less corroborating his own testimony, corroborating and embellish his own testimony. I simply don't get it. Why that is even remotely allowed.
As the court sees what the court doesn't know or wasn't there when he touched on the fact that after Donovan Thomas's murder, they went back and they saw that there were incidents that occurred that appeared to be act and reaction from certain groups of people. And then after the Donovan Thomas murder, that there were a series of retaliatory shootings. He did not go deep into them. There were incidents.
Claims of retaliatory shootings. Claims. More or less based on his word and his word alone.
That were listed that we are now presenting evidence of. At the time, there were objections to him talking about his investigation into those crimes. We alerted the court. We're going to put up evidence of those crimes. This particular one we did today is one of them.
Right.
So in as much as he gave a broad overview of, what things they saw occur. And that is at this address, there was a shooting. Then there was this shooting at this address. To the extent that there are details that are going to be brought out or that are challenged on cross-examination. Those sorts of things that were not ever talked about before will be talked about with Detective Dennis this go round. This will not be a rehashing, of a summary. That's not necessary. That would be a waste of time. This is going to be information that either he's not testified about or someone challenges another person on cross about. I don't think that at this point we can actually say, hey, this is all the stuff that we're going to talk about. We do know that it's going to encapsulate that area, that span of time that we listed for the defense in the court on that sheet. Well,
Your Honor,
Yes.
let me say this. I'm seeing these 4/28/15 shootings. I'm seeing on the state's list here, they're saying committed by Demekion Garlington, Antonio Sledge, Quindarius Zachary, and Shannon Stillwell. There is no evidence other than Mr. Zachary in his proffer trying to get better sentence, saying that Mr. Stillwell was there. There's absolutely no evidence, no phone records, no other witnesses, no ballistics that link to Mr. Stillwell. There is nothing that puts Mr. Stillwell in that case. My concern, and he wasn't charged either.
Okay.
What I don't want is, I don't know what Mr. Zachary, where he is, if we're going to hear from him, if we're not. But what I am going to have a motion if somehow Mr. Stillwell, through Investigator Dennis or some other witness that has no firsthand knowledge of anything.
This is a very good question, Mango Gelato. I am wondering, with all these guys locked up, if crimes are down in Atlanta. No, they are not. This gang, who, according to the state, were responsible for almost every crime imaginable in the Atlanta area, unsolved crimes, solved crimes, whatever. These are the guys that did them. You would imagine locking them up, crimes would be down. They're not. Not by a long shot. Nope. Nope.
Starts trying to bring my client into the 4/28/2015 shootings. And from the discovery, the only person that says that is Mr. Zachary when he was, trying to get himself out of trouble. And if Mr. Zachary says that, I will deal with that on cross-examination. But until Mr. Zachary says that, Investigator Dennis should not have anything to say about that.
All right.
Your Honor, the state, we are well aware of what the rules of evidence allow and don't allow. We will adhere to those. And as it relates to the evidence that we tender to prove the facts of this case as relates to each of these defendants, we will comply with and follow the rules of evidence. And I think that at this point, to efforts to sort of restrict what someone believes we may do is, at the very least, it would be a waste of time. It would make no sense for us to try and introduce through a witness we intend to put up a statement through someone else, through Detective Dennis, a statement of Zachary before Zachary ever testifies. That's wrong.
All right.
We're not going to do that.
I mean, that's
So-
good. I don't mind somebody alerting everybody to that as a potential issue. And I appreciate that you say that, of course, you're not going to do anything like that. Okay.
She
Yes.
lies in front of the court because
On
she
that,
gets away with it.
Over objection, retired Detective Dennis did testify as what I'd call a summary witness.
Uh-huh.
But the court needs to know that we never received an expert report for some of these people, not Miss Bell, who just testified, and those reports that we have on that incident on April 28, 2015, that found her to unfortunately, tragically be shot. A lot of what the Detective Dennis previously testified is total confrontation clause. I don't even know who he spoke with. He just spoke with people, interrogated people, interviewed people, people called them up, CIs. I have no idea if there was hope of benefit. And I think that's what Mr. Shart is getting to, because that's already happened. It's over objection, and I don't want it to happen again. And also, summary witnesses are not favored. That's United States versus Perry, P-E-R-R-Y. And that's 35F 4th. It's at 293. It's in Division 3, 5th Circuit, 2022. Specifically, again, we caution the government not to rely on improper summary witness testimony.
Okay, I found some statistics here regarding Atlanta crime rates. And roughly speaking, if you compare 2009 with 125.3 per 10,000 residents, the 2023 rate was only 55.6. Now, you can have difference of opinions on why that happened, because my argument is that it seems like from the foundation of YSL in 2012-2013, according to the state, crimes have dropped. Isn't that weird? Now, you can prove anything with statistics if you want to, but the last 5-6 years, it has been quite even. I mean, some years, certain crimes are up, some crimes are down, and the next year, it's the other way around. But if you want to interpret it, since the founding of YSL, crime is down in Atlanta.
So So I would also join in that same objection. And I understand it's a pre-objection, but
Okay.
Yes, I'm having a beer. It's Friday. It's 10 p.m.
And actually, I think that Ms. Love had shared with everybody, she had gotten through about, I don't know, it's not numbered, but 7 or so pages. Witnesses at the time, they were 81 through 110 with more detail than what's here of exactly what she thought the evidence was going to be at the time she put it together. And for Detective Dennis, he's on the last page of that. She's got listed the specific evidence that she, at least at the time she was putting it together, thought he was going to be testifying to this time around. And it doesn't, other than the PowerPoint, which has essentially been ruled out, it doesn't look like it's kind of summary testimony. Is that fair, Ms. Love?
Yes, and also I think that as I'm getting updates from team members who are also signed on, that in the Dropbox that I believe that we provided, we have, with even more specificity, photographs of Zachary and Copeland with guns, found at the Dunbar Center and at the Zachary arrest. And I think that this is something that has already been touched on. It's not, the court is correct, in short.
Okay.
We've been more specific.
Okay. Okay, sure. All right, so did you come back with further information? I think we had paused on something and.
We did, okay. So we have from Adele Avenue, there are several photos that we are still narrowing down that we got today. We will provide both all of those photos as well as the ones we intend to tender as evidence. My notes say that they are in the Dropbox link that 88 Atkins shared under CST Turner, but I don't know, my notes don't say that we have or have not sent them over to counsel for defense and to the court. So I'm confirming that.
Okay.
We have 15 additional photos and a floor plan for 1903 Drew Drive that is being sent over shortly as well. Let me confirm whether that Dropbox link was shared internally or with everyone. Just a moment.
Yeah. I remember listening into this and
Can't hear you without
Earlier
the mic,
today.
I'm sorry.
If they're looking for a recent email, I'm just trying to help. We haven't received anything from the prosecution team.
what we will hear in a while, spoilers, is she updates the Dropbox link, meaning she probably didn't send anything.
Okay.
And I don't know why Dropbox is allowed and why the defense.
I am being
Entertained.
informed that the
But the
Dropbox
judge allowed
link
it.
that everyone has
Landfill
been
days.
updated with those items.
Okay. So just, can you tell which Dropbox link it is? Because I know there are several.
The one with the 30 witnesses that has this particular witness on it.
Okay. Okay, great. All right, thank you.
You're welcome.
All right, so we were at what is numbered on this order of proof and exhibits list.
Yes, you Kerman. Dropbox is not secure. And for instance, do you remember the talks about the leak of a certain video? Well, if you supply the defense with a Dropbox that is not password protected, anyone can get into it. Anyone. Now it appears that it has been since then been password protected, but it wasn't for a good month and a half.
We were on witness number 21, Officer Pitts, and that's, I think, when we stopped to sort out the issue with the new photographs from Adele Avenue. And so moving on, we just talked to the next page, witness 26, Detective Dennis, we've just talked about. And I had written down from when we talked before, the number 87LL, was that the PowerPoint that we have already dealt with? I don't know.
What is the court's note regarding
87LL or 871L? I should write more detail in my notes.
1 second, Judge.
You know what? It was the PowerPoint. We've dealt with that. So that's fine. Okay. All right. So turning the page, we've got Mr. Arnold, his plea agreement, potential jail calls, and social media. And the jail calls would, again, only be, y'all are having him testify, planning to?
Correct.
So that would be, is that going to be anything other than potential impeachment?
No,
Okay.
I think that.
And those would have been the same jail
the
calls that were listed under Sprinkle also.
Well, yes, I was going to say, yes, and the one in particular that I'm thinking about is I play it in my mind whether it would be this particular one on January the 10th would be considered impeachment. It was right after the murder of Donovan Thomas, and
If I butcher your names, I apologize. If I by accident get it right, yay!
Mr. Bradford, a call from Mr. Arnold to Mr. Bradford.
Okay.
So it's a call that the state may tender on its own. I think is one that the conversation needs to be heard. I think it's something that can't be captured in an
Okay.
examination and a response.
All right. So is that one that we need to litigate anything about?
Hey,
Yes.
Larry.
The defense thinks so, so I guess we need to litigate it. There doesn't sound like there's agreement. Okay. Is that something we can do now?
I just, if I could hear the specific objection so that I could respond appropriately. Mr. Whomever said that is correct. It is a 15-minute call, but
Okay.
I believe.
I'd ask the court just to allow us to know specifically the objection to it since the call has been identified.
Okay.
If I'm thinking of the right call, there's different people. Mr. Arnold is in custody, by the way, Your Honor. He's arrested on or about the 6th day of January 2015 outside of Club Crucial. You heard about this fight at Mr. Copeland. He's arrested outside. And I believe he's charged with either a small amount of marijuana or a gun or something to that effect.
Okay.
It's now the 10th day of January 2015. It's approximately, my memory is 7:42. I may be wrong. And it's clearly a collect call. If the voices are identified the way the state says, it's Mr. Bradford at first and Mr. Arnold. But then there's another woman who's on the phone, who I am not going to stipulate who it is. And she gets on the phone and supposedly says something potentially about Mr. Williams. I am objecting to that portion if that person is not testifying. The person I believe it is, but I'm not stipulating, is Miss Morton. And I heard today that the state said that they will wait on the Honorable Douglas Weinstein to call Miss Morton to promote the alibi defense for Mr. Kendrick. So I would move to exclude that portion. There's other portions, and I just have to get my notes, Your Honor, but I can do that, that are not relevant. They're talking about, I don't know, the jail food, or I don't know. I don't want to make specifics,
Sure.
but it's nothing to do with anything happening in our case.
Okay.
So understanding, at least I'll respond not to the jail food, but because that was at most a few words, but this is we believe, calls between co-conspirators who are Mr. Arnold reaching out at first. I believe he may have initiated.
For me, if you call somebody a co-conspirator, they should be indicted in this trial. This case, 28 defendants. If anybody is outside of that, they are not co-conspirators, they are not unknown co-defendants, they are people. But according to Georgia statutes, they can be.
Actually had one purpose for reaching out, but the conversation turned to an alert or an informing of the current status of something that had just occurred. We believe that the thing that had just occurred that is a part of the larger conspiracy that is count one is the murder of Donovan Thomas. This is Mr. Arnold reaching out to Mr. Bradford, Mr. Arnold asking, what's up, how things are, how are y'all doing? And Mr. Bradford saying some shit just occurred. He's, we believe, being intentionally selective with his words. And Mr. Arnold is asking where other people are. Miss Morton gets on the phone. Mr. Arnold specifically asked where Mr. Williams is. Ms. Morton says to Mr. Arnold, "Hey, Goldilocks." Mr. Arnold at some point had his hair dyed blonde gold, but she references him. And at some point, of course, Mr. Arnold asks, just to speak to the idea of we don't know who it is, Mr. Arnold asks Mr. Bradford, "Who is that?" And Mr. Bradford, I think, says Bushi. And as they are apprising one another of what is happening outside the jail, as they are apprising Mr. Arnold of what's happening outside the jail, we believe that this whole conversation is a conversation between co-conspirators serving to inform each other of the current status of the conspiracy, which therefore furthers the conspiracy itself. It serves to maintain a certain level of cohesiveness among them. And each one of the people who are taking part in the conversation are persons we believe who have just had some involvement. If they did not switch cars with, provide cars with, provide transportation for the people we believe are involved in the murder of Donovan Thomas. They are advising each other of where the participants in that activity are at the moment that the inquiry is made. And I think I said that Mr. Arnold asked for Mr. Williams. It may have been that he asked for Mr. Kendrick. So that's a mistake on my part. He asked where Yak was. And I think that in responding where one of them was, Mr. Arnold was told that they were either with Mr. Williams. There was a reference to their current locations. And at this point, the entirety of the conversation, we believe is one that is informative, one that falls squarely under the co-conspirator statement category. So at the very least, there is that. We do intend to inquire of Mr. Arnold about that. I don't know what he's going to say.
Okay.
But, so it has two, we believe that it would be introduced in one of two ways.
So if Ms. Morton is the person who answers the question of where Mr. Kendrick is and says where somebody else is as well, are you contending that she's an unindicted co-conspirator?
Oh, she is. We believe that she is, yes, an unindicted co-conspirator. She is, we're not saying that she, participated in the murder of Donovan Thomas, but in as much as her actions this night and what she does later on, I think the conversations that she has with Mr. Kendrick, we won't be trying to get into what she told the police, but I'll just tell the court, she tries to provide an alibi initially. It's sort of, she's lying for Mr. Kendrick later on when presented or confronted with the surveillance footage She's kind of coy and, saying, I don't see who is that? I don't see that. So she, yes, is a part of the conspiracy in that sense. She's not indicted. But when we're looking at the broader conspiracy that involves YSL and protecting its members and carrying out its purposes, she is a part of that. She's not indicted.
Of YSL?
Yes.
Your Honor, I would ask that this discussion be tabled for another day. Mr. Weinstein is more on has the details of this conversation and this evidence.
Okay, so I am going to need evidence other than, like, what the state's evidence other than this one conversation is to establish that she's an unindicted co-conspirator. I assume, Mr. Steele, that would be your objection?
Yes, I have a series of objections under 24-801D2E, and specifically, and a good case I think is Stafford STA FFORD versus State 312, Georgia 811. It's in Division 5A as in Elisa, 865 Southeast 2D, 116, 2021. And Your Honor, my position is going to be just the law, like you've been articulating. The state first has a requirement by preponderance of the evidence that a conspiracy existed, and which is what I focused on and what the court just focused on, that the Honorable Court focused on, that the conspiracy included the declarant and the defendant against whom the statement is offered. And the statement was made during the course and in furtherance of the conspiracy. And when you hear the recording, you may make determinations that, one, if it is Miss Morton, if someone can identify her voice, that she is not a part of the conspiracy, and that would break the chain. And two, it may be a, quote, spilling of the beans, because the entire conversation is nothing to further the conspiracy. If anything, and I'm not saying there's any conspiracy, but if anything, it's very vague and something happened. And I'm not saying that personally, I'm going to argue that it does not further conspiracy. So there's many different objections that I will have.
All right, so that is something we need to come back to.
Yes, Your Honor.
And so far, I apologize.
Go ahead.
So far, to my memory, and please correct me, someone, I don't believe there's any testimony about Miss Morton in this entirety of the case. That's my belief. And the state just said that they potentially, I know they could change their mind, but potentially not going to even call her.
I'm not certain what when Mr. Steele says there's no testimony about Miss Morton. I'm not sure if he means there's not.
No, he said evidence. I believe. Let's hear that again.
I believe there's any testimony about Miss Morton in this entirety of the case. That's my belief. And the state just said that they potentially, I know they could change their mind, but potentially not going to even call her.
I'm not certain what when Mr. Steele says there's no testimony about Miss Morton. I'm not sure if he means there's not any that's been presented, or he hasn't seen where any could be presented in discovery, because
I think that any has been. Yeah, he's nodding his head in affirmation. Okay, well, I mean, as long as it will be.
Yes, and I know that we've already shown the surveillance footage at the gas station. This is just in terms of the idea of Miss Morton. She's the person getting out of Ariel Bax's car, getting into the Pontiac Bonneville that Javoris Bradford is.
This is a really good point from Manders 13. How is this okay? This is public record. That woman, who is now claimed to be an unindicted co-conspirator, her life can be ruined. A future employer Googles her name, finds out she was mentioned in the YSL-Trial. Oh, I can't hire her. Unless they are indicted or a witness, their names should not be on the record at all, in my opinion.
Is driving initially, that then Diamante Kendrick gets out of and walks to another car and comes back and ultimately gets into the driver's side of.
This is the video from the gas station that's the night of?
Yes.
Okay. And
Miss
it's allegedly like immediately after?
Oh, it is. It's immediately before. It's about 6 minutes before Donovan Thomas is gunned down 100 yards away.
Okay. And she is identifiable?
Oh, she's identifiable, identified.
All right, well, that sounds like that might do it, but we'll circle back on a day when Mr. Weinstein is here at Mr. Howell's request. And I assume there's going to be somebody that says, that's able to testify that her kind of street name is Bushi?
Yes.
Okay. All right. Thank you. So that is that jail call. And then what about Mr. Arnold's plea agreement? Is there a similar kind of factual acknowledgements as there was with Mr. Sledge?
There is with each defendant that pled guilty. And also, as I was over the time that the court broke from when the jury was here, I was going through my emails to try and finish up the collection of correspondence at the time that I was speaking with Mr. Merchant, his attorney, to tell her he's coming up.
Okay.
And I found that same series.
Did you hear that name? His attorney, Miss Merchant. That is Ashley Merchant. I've heard that name before. Yes, Miss Merchant was Mr. Steele's attorney when Judge Glanville found him in criminal contempt. Miss Merchant schooled Judge Glanville on the actual rules regarding and the difference between civil and criminal contempt. So that is why you recognize that name. Let's listen here.
Of emails that I'll be sending to the court and to counsel for the defense regarding her requested changes,
Okay, well,
or his, or however.
I'm going to hope that we don't end up calling another attorney to
I
the.
don't- Judge, I didn't want to call the first one.
I didn't really go that well for you ultimately. I don't know.
Well,
I hope you're not thinking of calling another attorney. She doesn't plan to, and then the judge say, it didn't really go well for you ultimately. And that we here have some bias towards Mr. Wright. I do believe under the circumstances he did okay. But when the judge says, oh, that was bad for you. Oh, take the hint, Miss Love. Take the hint.
let's see.
Okay. All right. So
How can you not have the ability to giggle? Listen to Miss Love's approach, attempt to giggle.
do that well for you ultimately. I don't know.
Well, let's see. Feels
Seriously, how can you not have the ability to giggle?
Okay. All right. So in the event that the same or a similar thing ends up happening, I guess I'm going to circle back, when we were talking about the admissibility of the factual acknowledgments plea agreement before, and I ruled that it was admitted, and Mr. Sharp said, okay, well, that may be, but there still may be some continuing witness issues. And I said, well, we'll deal with that later. I was thinking about that yesterday, and I also think that there are continuing witness issues with that.
I don't disagree with the continuing
Okay,
witness
so,
part.
basically that never got displayed to the jury because we only admitted it after the jury was gone and the witnesses were both off the stand. So really, that's not anything they'll ever see.
Actually, Judge, I tendered it I think I tendered it in front of the jury. And at the time, there was an objection.
Right.
And I believe that to the extent that the court admitted it, it can be published. It can go back.
Okay, well, I don't know who you would, I guess you don't necessarily need a witness to do that, but.
And since the court did bring that issue up, there was another matter regarding the factual acknowledgments that I wanted to bring to the court's attention.
Okay.
There was the testimony from the attorney.
Yeah, I think Miss Love is actually contemplating it. And one of the reasons is because Miss Merchant is eating her boss alive. Miss Merchant going after Fannie Willis. And Miss Merchant is doing great. So this might be some kind of retaliatory attempt from Miss Love. But yeah, she might try. And here's the thing. Mr. Wright is a lawyer. He's a lawyer. When you approach him, he's a lawyer. Miss Merchant is one of the people you call the lawyer, the attorney extraordinaire. Special bendy bros, what does Ashley have to do with this? Ashley Merchant represented one of the people who took a plea deal, who is up in the near future. And Ms. Love is actually contemplating calling her to the stand. And I have to say, yes, please. Ms. Love, please do. For streaming and broadcasting reasons, please call Miss Merchant to the stand. I really want to see that. Oh.
Regarding two portions of the final document, specifically as the only two portions that were taken issue with.
Right.
One being number 3, which the court remembers,
Mhm.
but number 8
Right.
specifically.
Mhm.
And of course, the argument will be made. There are certain arguments that are right for that, but the thing about number 8 that I wanted to bring to the court's attention is that number 8, and this is not something I felt was I didn't feel it was something to go back and forth with the witness on the stand about. He testified, his memory was, he didn't remember seeing it.
Right.
But number 8 was a distillation, a pulling apart of a iteration, the one right before it that he took issue with.
Mhm.
And the reason the state tendered states 460 Yankee as well as 452 and 453 is that 452 contained the statement that 460 Yankee addressed, and in 460 Yankee, in as much as there were certain things that were not contested but clarified, but the personal knowledge part is a specific thing that wasn't denied, but that was implied. And I'm just saying that instead of having what the state did, what I know we did,
Thank you, Anna. Thank you.
when Mr. Wright says he doesn't remember, that's fine.
Mhm.
But when we provided to him the document that had it pulled out, there was not.
Let's check. 9937. We are 63 from 10K. 63. There are currently 274 people watching. At least a dozen or 20 or maybe 40 haven't subscribed yet. So please, if you wouldn't mind. Thank you.
I don't know how he says he didn't see it, but there was not any indication from anyone that was incorrect. That wasn't just taken out of the air. That
No,
was.
I know that it wasn't, but we have already talked about that. I know what the state, I know and understand how it is that the state got to and believed that given the comments he made, you all could say, well, okay, still, whether he knew it was planned or not, he still knew it happened and that they were responsible. But it doesn't actually say that in the iteration that got changed. And
How
so
about
that might have been the state's understanding of it. But, I mean, it is what it is. And
And
you didn't explore that with the witness anyway. So, I mean, at this point,
Yeah. You didn't bring it up. It doesn't explicitly say what you claim it does. So off you F.
I mean, obviously that was a protracted examination that I did not want to make more protracted, but I do think that in as much as there is an attempt to convince the jury that essentially these are made up things that the
that you
state
just
put.
slipped it in.
Yes.
Quest for SM1. Question: can the motion in front of the Georgia Supreme Court regarding the ex parte lead to the entire case being dismissed in addition to any rebuke of Glanville? No. what the Georgia Supreme Court have in front of them is only Mr. Steele's contempt of court sentencing and found guilty and the procedural against that. Now, that ruling they make, can then be used by the defense to show partiality of Judge Glanville, and thus in an appellate issue bring it up. So hopefully, and I said this in the video in the premiere earlier today, I hope the Georgia Supreme Court will address the ex parte meeting, because it is a really dangerous precedent if that ex parte meeting is deemed lawful.
I mean, Ms. Love, then put somebody else on the stand. But I mean, you telling me this, I mean, it doesn't do any, I mean.
The reason that I was telling the court that was not to try and completely relitigate an issue, but as to the section that dealt with his response, not the whole response, not that it's 460, but I would ask if the court might consider reconsidering just us putting in that one part that he responded to, the way that he responded, and then the ultimate version, so that at least before the jury is where that came from, since there has been this continued effort to convince them that we make stuff up and we just, out of thin air.
Well, I mean, you're the one that decided to put him on the stand.
I don't regret it, or I don't think that that's the problem. That maybe, obviously minds can disagree. I don't think that that's the problem.
Okay, well, if it were as clear as somewhere in the earlier version was the statement, I personally know that members of YSL were responsible for this murder, or whatever it said in the ultimate version. If that were in the prior version, that would be one thing, but that's not in the prior version. So I have thought that issue through.
Yes,
and I understood that to be your argument yesterday or the day before, or whenever it occurred, the day before and yesterday. And I just.
Yes, Your Honor.
Okay. Appreciate you giving it yet another try then. And I'm being facetious when I say that.
I know you are.
Okay. So anyway, with regard to if the same or something similar comes up with some other of these co-defendants who have pled, then just be aware that, and it sounds like we're all in agreement that it can't go out to the jury anyway. So if you want them to see it and it does get admitted, you'll need to display it at that time. And if you come up with a way to publish this other one, then let me know.
Okay. Okay. Thank you.
Okay. All right. So then if we turn to the next page, we've got Ms. Latner's again. I know we went through did we go through every CAD report she's gonna be testifying to when we were talking about the hearsay?
I think that we did.
Okay.
The
All right.
court
So
ruled
that
on,
part's
yeah.
taken care of. All right. Then there's Mariah Smith, and that says interview. Is that like with police or with, who is that with?
Yay! Kevin Kirksey became a member. Thank you so much. You now have access to all my members-only content. You have access to all the members-only emojis on YouTube. And the link to Discord is in the community section of my YouTube channel. That brings us up to new members gifted or by their own accord to 30. Yay! Nice. Thank you. And welcome.
It was an interview with the police, and she also testified at trial. We don't need to, or we would
She's
not.
already testified?
No, not this trial.
Oh, at a different,
in the murder
the
trial.
2015
Yes.
trial.
No, it wasn't 2015.
Some other.
2019. Yes.
Okay.
So that we would not need that for any reason other than if
Impeachment.
she,
Okay.
right, or substantive.
Okay. All right.
Or inconsistent statements.
Right. We're on a different act at this point. I see. And same for whomever the
Right.
two people are?
We
Good.
We had Rodney Uten and Bernard.
And or Bernard Mitchell, and you were going to call one or the other.
Right.
Okay. Same with them.
Yes.
Okay. All right. Detective Hogan. And that we know we need the interview of Ryan's not coming in. And then we've already done Mr. Ryan's social media, right?
I don't think we've done all of it. I think that's something that we were,
It's
Ms. Hilton and Ms. Abbasi
All right. Y'all are going to,
are still
That's the
discussing,
email.
and we have,
Okay.
Email I sent.
okay.
You're
Great.
supposed to like get back to me.
yeah,
Yeah.
Okay.
Ms. DeWilliams and I have been
Great.
communicating.
All right. Mooney Lee, then that's going to be play agreement, same kind of similar thing. And then text message, anything we need to litigate with regard to that text message?
No, I don't think so.
No.
Anybody? Okay.
Because they lay the foundation.
Yeah. Okay. And then blog videos, social media, and music when we flip the page.
Yes, so
Oh, come on. What's going on? I'm going to check here if there's something up with my internet. I don't think so, but you never know. No, this seems to be YouTube to StreamYard issue. And I will show you why. Because I just did the broadband check and download 305.9 megabits, upload 492.01 megabits. There's nothing wrong with my internet. Absolutely nothing. So the world of doom that shows up once in a while is between StreamYard and YouTube's, not because of me.
I don't know what objection anybody would have, given that it is Mr. Lee who's on the stand, but the
Okay.
video itself is specifically the blog video. We believe is definitely an overact. They are talking about the meaning of certain terms, slat, and Mr. Lee makes a comment into the camera and then puts his hand over his mouth and says, shh. So that video itself, we believe, constitutes an overact in furtherance of this
Okay.
conspiracy.
And then y'all are familiar with the, whatever the social media and music is going to be. So if there are any issues,
Oh, Lynette's attorney asked, is this case as bad as some of the ones I've been dealing with? I think you're trolling. but for all the other bad, for all the other who tries to troll, that is an example of good trolling with humor. It's fun. You got the other minority who goes, I poo through my mouth kind of thing. Be original. At least be funny. Let's get back to this. Thank you, Lynette's attorney.
Hesitate to say yes to that because music, I mean, I don't know exactly what the state is referring to the extent that a song by Mr. Lee has been identified or is listed as an overact, which I don't recall off the top of my head, but I guess I'd have to know what the music is and then there's a 403 analysis, there's
Okay.
Baker, the Baker case that came out earlier this year. And of course, even though it's not our client's statements, it would be affecting our clients. So yes.
what's that site?
Judge, I don't think that Baker, it applies
I
to
don't
this
know
set
that
of
I've
circumstances
looked
at
that
all.
case, so-
Well, Baker was
It's
Baker dealt with a music video, but it was really a 403 analysis
Okay.
case. And I can get the site. We dealt with it earlier in
Well,
this
I'll
case.
just put in,
But
I don't think Ms. Love is in any position to address any case law that the defense brings up, because she is 2 years late with some of her case law. 2 years.
Baker music video in 403, and I that in 2024.
Yes.
Okay.
But again, I don't know specifically when they say music, what we're
Okay.
talking about. So
And is this Mr. Lee's music or somebody else's?
Mr. Lee's.
Okay.
318 Georgia 431 is
Thank
the
you.
site for Baker. March 2024.
Okay. Do you know what music?
Yes, there was the song, and there was also this, I think that this particular issue was litigated and decided in an order that was filed by the previous trial judge on November 27, 2023.
Yeah, no,
Oh, so you're just
yeah,
asking
that,
about
not
which?
that, not, you're not talking about that issue. You're,
I am.
You
We
are.
did. Now, I'm
You
going
are.
off my recollection. We did litigate songs. We litigated a song by my client. We litigated some songs by Mr. Williams, and we litigated a song by Mr. Kendrick. I do not recall litigating the Woony Lee song. Mr. Steele is
They did not litigate Mr. Lee's song.
affirming my recollection. But so we do need to address that at some point.
okay.
I think under
What was the date of the order?
November the,
Baker. Is
20.
Baker here? Did I miss you?
November 27,
Baker.
2023.
Oh,
Okay.
Nick Baker. Okay, I thought you meant Broken Baker. Really?
So, on page 40, and this is not necessarily specifically talking to a lyric, but the court ruled that the lyrics evidence referenced in Division 8 supra is admissible against defendants Lee and Kendrick as a party admission and all defendants as a co-conspirator admission. The court found it relevant to count 1 RICO conspiracy, Acts 17 through 19, and count 2 murder, and that it is admissible to show actus reus mens rea and as proof of the existence and nature of the gang enterprise, the criminal nature of YSL, the connection of the defendants with one another as intrinsic evidence, and under OCGA 1615.3 and 1615.9.
Okay, but was this particular song included in section 8?
I'm making sure about the lyrics that we referenced in section 8, Your Honor, if the court would indulge us. One moment.
Okay, no problem.
Yeah. Were they? Were they? Skipping.
It is referenced. It is referenced on page 35, number 13. Where are you from? Woony Lee is Slime Life Shouty. And specifically, where are you from? I'm from Believeland. Throw your setup, YSL. The ops hate the crew. We getting this paper and we ducking cases. Free Lil Shannon. He the one that had him running with the cannon.
Okay, looks like that was already litigated.
I'm going to suggest that we will go back to see to the video of court, because I mean, sometimes I don't know who writes the order sometimes. So I just want to make sure that it was actually litigated in court.
Okay, well, if it,
This is, in my opinion, is an example where they litigated some, but Miss Love slid in the order. That is what I believe happened, because I have no recollection of those lyrics being litigated.
it was set forth in a motion or brief or anything, whether it was talked about in court or not, if it was included in the order, the decision was made that covered that. I mean, the court, the predecessor judge included that in the order.
Yeah,
And
so it might be Judge
are welcome to
Glanville
go
who
Look at
decided
what the
to bring
transcript
it
said,
in.
but I don't think it matters whether it was specifically talked about or not, as long as it was included in what
I will give you an example why music should not be admitted as evidence. I will give you an example. Norwegian black metal from 1988 to 1994. At that time, there were a grand total of, I believe, 3 or 4 murders and the arson of churches. Not one of them used lyrics from bands who were involved, band members who were involved in that, in those charges or convictions or the trials, because it's speech. It's speech. Venom is British, but thank you, YSL-Trial. Yeah, Norwegian black metal. Mayhem is infamous for being highly involved in both arsons and murder, and self-ending for that matter. If you want to, I can make a video once we get through. And for instance, let's say it's a break in these proceedings. That might happen. If you want to have a stream where I go through the Norwegian black metal murders, I can do one of those. And no, Dave, German pop is not the same as Norwegian black metal. But let's continue with this one.
The court was considering.
Okay, well,
Okay.
we're going to look at that.
All
Thank you.
All right, and then it's his own social media, and it's been sufficiently identified that, or has it been sufficiently identified that the defense knows what that means?
We are almost up
By
to
social
today,
media.
day 129.
Yes, Your Honor, I believe it
When
has.
Ms.
Yeah.
All
Love-
right, that's fine.
And actually, they are most of them are listed in the indictment themselves
Okay.
as overacts. And I think there was a reference earlier to something being listed as an overact, that the state reference is an overact. I did not say it was listed. I just said it is, or
Okay.
constituted one.
All right. And then next we've got either Detective Viverito and or Mike Sprinkle with the social media post detailed there, and then Mr. Ryan's conviction, which y'all are going to brief me on various topics about. And Ms. Abbasi was here yesterday when we were talking about what kind of briefs and case law was owed, so she'll know what that was. And Ms. Love, I know at the time when you gave us this, that's the more detailed exhibits, that was as far as you'd gotten at the time. And if you didn't continue on, that's fine, because I said, no, don't take so much time doing that. Just give us, a general list. But if you have done more,
We can do more. I can't say right now that we've done more.
if you haven't, no, I'd rather you focus on the other
Okay.
tasks I've given you. I just
Okay.
thought, hey, if it's sitting around, we'll take it. But
Okay.
if it hadn't been generated, don't worry about it.
Thank you.
Okay. All right, so then Colin Russell, any issue with the exhibits that are listed next to him? I wouldn't think so. Would y'all mind responding so I know the answer?
Yes, Frank Zappa and John Denver regarding musical content and censorships, and famously, Dee Snider from Twisted Sister showed up in court and completely obliterated Tipper Gore. Tipper Gore, the wife of Al Gore, who infamously wanted to censor everything she didn't like. Everything. The claim from the, wives of senators for censorship group, I don't remember, claim was that a lyric by Twisted Sister was about something. Oh, the claim was it was about bondage, and that is immoral. Dee Snider went up and testified to the Congress. No, this song is about a friend of the band who passed away. And he famously said, "We cannot dictate how people interpret our songs. If Miss Gore wants to see bondage, she will see bondage." And Al Gore sat there in Congress going, "You said what?" And well, he didn't say it out loud, but he was so mad. Yeah, the parental advisory label. Thank you. Which is, we had those in Sweden back in the 80s and 90s as well, thanks to Tipper Gore and whatever parental advisory thingy. And we actively searched for those albums who had that label. It went so far that record labels made their own labels saying parental advice just because they knew they sold more. Oh, it was so funny.
Somebody. It's okay. Okay, so no, I was just moving down through the witness list. So we're on Colin Russell now. He's on page 9, number 36. Does anybody anticipate issues we need to litigate beforehand with regard to any of the exhibits that are going to come in through him? And I don't know whether y'all are thinking or whether you're just like, no, I don't know.
Folks, we are 52 away. 52 to 10K. Will it happen in this stream or on the panel show? I don't know. 52 to go.
No issues for that particular.
Okay. Is everybody good? Does anybody need a bathroom break? I assume y'all will just tell me if you do, but silence equals assent, I guess. All right, DeJuan Maynard on the next page, social media. Any issues on that? That's going to be his own social media.
Yes.
Okay. Okay. All right. Is there any issue? Everybody has all the body cam that might come in, right?
Got it all.
Okay.
Hey, Sleepy
Okay.
became a
Number
member.
41,
Thank
Officer
you.
Francis.
Thank you.
Social media. Is that somebody else's social media then?
You now also
That
have
were
access
screenshots
to
that the victim sent. too.
everything.
Okay.
All my members only
Observation.
All
content,
right.
members only emojis, and my Discord. Which brings us to 31 members today. Ah, that's so good. Thank you so much.
Unless there's anything else on that page, I'm turning to the next page. Miss Stanley, there's a jail call listed. Are there gonna be any issues there?
No issues for that, Your Honor.
Yeah. The beer I'm drinking is called Norrlands Guld. Yeah, well, it's a lager and it's a light beer. It's only 3.5% alcohol. And it's quite decent for a lager. Oh, come on, stop doing. Not the World of Doom! I have great internet.
One of the parties on the jail call is alleged to be a co-defendant in this case.
Okay.
So to the extent
Oh, come on.
that that particular person, obviously we won't have an opportunity to question that person's represented, that person's under indictment.
And do you mind telling me who it is?
Mender.
Okay.
So that raises somewhat of concern for us.
No, Otto, I will not do like the other LawTube Nick did. The only Coke you will find me with is Coca-Cola.
Because y'all aren't, in what concern exactly?
Clearly wouldn't have an opportunity to cross-examine that person. That person obviously is under this indictment. It's not on the witness list as a witness. So the issues that arise with respect to that concerns us, obviously.
All right.
I might be incorrect, but I think we've already litigated that and sent the court the order. I'm checking with my team.
Octavia, it did it again. Yeah, like an hour ago. It's really weird because I mean, it's only on page like 85. Warning, local storage cache is full. I mean, if you want to. I really like that sweater. Pretty colors.
And the judge mic is hot. Hey, Siobhan. Good to see you. Hey. Skip ahead.
Hang on. I don't know. My court reporter's ready. She was fixing something on my real time.
Yeah. I will close down all windows between this stream and the panel show. Oh, come on. $749.51. Update.
Hang on. I don't know. My
Oh. What the F is going on? You saw it yourself. I have no issues with my internet. Oh, closing the chat. Oh, let's try that. Thank you. Yes, we all know Dave considers 3.5 as hard liquor because Dave is a lightweight. He gets white woman drunk after half a bottle of Prosecco.
okay. No. Thank you, though.
So my concern, which is it's alleged that he's one of the Mr. had been litigated previously.
November 16th, 2023 was the date the order was entered.
All right.
But that was my concern.
Okay. Thank you.
Yes, sure.
Okay. And Your Honor,
Yes.
just for full context, the last line of the order reads that the court grants the state's October 24, 2023 motion to introduce Gary Holloman's statement to defendant Mender's mother and defendant Mender in the three-way conversation the day after the robbery as residual hearsay evidence pursuant to 24-807. That's different than what, it's in the same call, but I heard Mr. Matthews reference something.
The residual hearsay issue I actually did look at again, and I came to the same conclusion. So you're talking about something different. Is right?
Yes.
You're talking about kind of, I guess, confrontation issues. Was that litigated?
So, I don't know that there's,
I mean,
when we say
I wouldn't
confrontation,
think that's
it's not a confrontation clause,
testimonial.
right, in any way.
Oh, go screw yourself.
Bruton issues. Okay, so it's not confrontation issues because it's not testimonial, but there might be Bruton issues.
I don't
I
think,
mean, I don't know. I'd have to listen to the,
I don't think Bruton issues would exist in this type of context.
I
think
wouldn't
it's-
either. So, okay, so what then?
Well, I clearly wouldn't have an opportunity to cross-examine this person. This person has certain rights.
Okay.
Because they're on the indictment.
Well, they're not, they're not testifying.
That is part of the issue.
But when you have a right to cross-examine somebody is when they're giving some kind of testimonial evidence against you. So even if they weren't on the stand, if this were a testimonial type statement, then you would have a right to cross-examine and we would otherwise have a confrontation clause problem. But you don't have the right to cross-examine on something like this if it's not a testimonial type statement. So, okay.
I understand that.
Okay, so maybe I'm just not following what it is that your argument is going to be.
I know that we're going to be.
So-
Okay, well, all right.
The prosecution is allowed to
Okay.
present something that is not allowed to cross-examine on. Yeah, that seems fair.
Okay.
I did want to bring to the court's attention, Judge, that the relationship that was represented to the court on the prosecution of Mr. Holloman and Stanley and Mender, I think they indicated that this was supposedly his nephew or something.
Right.
I don't believe that is in fact the relationship. It's not a nephew. Mender was not a nephew, but that'll come out later too. Because that was part of I think the court.
I had noted that as yet another reason why it was okay for it to come in.
Hey,
But, I mean,
Martina Nem
The-
became a member. That brings us to 32
So I
members
think
today.
that Mr.
And
Holloman, I think they,
you as well. Oh, wow. Whispers. That brings us to 33 new members today. That is amazing. Thank you so much. Thank you. Again, you now have access to members-only content, members-only emojis, and my Discord. Thank you so much for becoming members. Thank you.
Comes in against Mr. Williams.
okay, so those are two of the examples of types of evidence that come in under 807, but that's not the entire universe. So the fact that it isn't either of those two things isn't determinative or dispositive. And I don't know that a limiting instruction would be appropriate here. And you're welcome to craft one and present it, and I'll consider.
Oh, for freak's sake. Well, Mr. Jingles, please do not sharpen your murder mittens on my new chair. Please don't. Okay? Please don't. Okay. There's obviously something going on. I will make a quick reset. And I will be back as soon as humanly possible because, to reset the cache memory, I guess. I will be back in a few minutes. A minute. 30 seconds, maybe. I don't know. And I'm back. All right, let's try again here. I hope. Dun dun dun. Dun dun dun. Dun dun dun. Dun dun dun. There. All right, let's try.
So the fact that it isn't either of those two
Now come.
things isn't determinative or dispositive. And I don't know that a limiting instruction would be appropriate here. And you're welcome to craft one and present it, and I'll consider whether I think it's appropriate, but
I appreciate it. I was always taught by your court and the courts in general that residual hearsay is really, and I'm just looking,
I know.
it says, if you don't mind, it says, it must be equivalent to cross-examine former testimony, statements under the belief of impending death, statements against interests, and statements of personal or family history, not just that people are related, and that these categories of hearsay have attributes of trustworthiness not possessed by the general run of hearsay statements that tip the balance in favor of introducing the information if the declarant is unavailable to testify. And that's another thing, and that's, by the way, I was reading out of Ash, ASH versus State, 312 Georgia 771. It's in division. It's in division 3B as in Barry, and that's 2021. But also, a person to that conversation is available to be cross-examined. I'm not talking about a person with a Fifth Amendment right, but there's another person who I believe is available to be subpoenaed and is on the state's witness list. If I'm wrong, I don't want to be wrong, but I believe that what I said is accurate, that the person is here in Atlanta and could be subpoenaed. So I would ask again,
And who is that?
Miss Mender, but that, if Mr. Matthews can help me with the name.
Who?
So we're referring to Kiana Skin.
Okay.
That's what we're referring to.
Okay. So
So they have a witness they can call
I mean, this
about
is-
the specifics.
the witness that this would come in with.
So we do have Tiana Stanley on the list.
She's witness number 45
Right.
on this. That's
right.
who it's coming in through.
Right, that's what we have. That's literally the evidence that we have next to her. And of course, the court's aware that Mr. Holloman is deceased, and so it falls squarely under, we believe the court made the right ruling, 24-807. We believe all three requirements under the statute are met.
Okay. All right, then we come down to Sergeant Henderson with Mr. Huey's interview and social media.
Oh,
Does the court see Officer Cornbarger still on?
Yes, but I mean, all that says is testimony. Okay.
And as far as Henderson goes, I've reviewed everything, so we're okay.
Okay. Belknap.
Belknap.
Any-
Belknap
guess
is
if
the
the search
witness.
wasn't-
Yeah.
Yes, with respect to Belknap on that, what's on Belknap for us, Judge, is some items that were found concerning Chandler Durham. And our position is that this particular information that this investigator would testify to is not part of any overt acts. I don't believe Chandler Durham is on the witness list. I believe it's intrinsic. So I would argue that that information should be kept out.
Ms. Love?
Just to make sure that I understand my colleague's argument is that because Mr. Durham's name is not on the witness list and because this act is not listed as an overt act, it should be kept out. Is that the entirety of the argument? I just want to make sure before I respond.
Is that the argument?
I didn't say, I say confidential.
You did not say
So they don't have the witness and the crime is not an overt act. Really?
confrontation
Really?
clause, but if we're talking about items found at the home, this is items that investigator Belknap found
Allegedly.
Time of
in the search of Mr. Huey's apartment, and they ended up being, I guess, I don't know, allegedly from Chandler Durham?
That's correct.
And is the issue who actually says they are from Chandler Durham, if it's not going to be Chandler Durham?
So I know that we had Chandler Durham on our witness list. We have pared things down. If it turns out that we ultimately left him off, and I'm making sure that we did, that's just one more person that we'll just
Add back in?
Yes, that we'll just add back in.
Okay, so, I mean, that would just be like hearsay if he says Chandler Durham said these were his.
Unless Chandler's coming to court.
Okay.
Confrontation also.
And this is also a circumstance where, so just to respond to a part that I don't think is material to the objection, but Chandler Durham is part of one of the overacts listed. I think.
Okay, well, I mean, I don't think that's their real
Right.
point. I think it's
Right.
who, how can he say these are his?
We have to add it back.
All
But
right,
also
so-
we have Defendant Williams' sort of implicit statement that they're his, because he's admonishing, he's warning Huey that if he doesn't take it back, somebody gonna die. But that's just, so we,
Yeah. Well, I guess maybe, even though I appreciate your efforts to pare down your witness list, this is one witness you're going to need to add back. As the defense is otherwise going to
understood. Your Honor.
object, so, okay.
That circumstance may come up again.
All right,
Okay, we have less than half an hour until the panel show, so I'm going to skip to 2 days, so we at least get a few minutes without being forced to listen to Ms. Love's voice. And while we do that, I'm going to share this. 48 to go to 10K. 48. 48. So, would it be in this stream or in the panel show stream? Or will we have to wait another day for that to be switched over? I don't know. We will find out. But first, today. Oh. And dun, dun, dun. Yes, that here is where they go into, Friday wasn't a jury day as well, because the jury issue continues.
however, I'm hopeful that we can get through some further evidentiary issues today. And I know we can at least, finish going through the last 12 pages or so of the exhibit and witness list. And beyond that, I don't know whether anybody's ready with any of the other issues that we were going to get to at some point or not. So y'all just kind of have to let me know. Oh, sorry, y'all, when they tell me we're ready, and that everybody's here, I guess I should stop and actually look. Okay, well. Didn't know you weren't here. Came in because they said everybody's ready. All right, so if y'all can give me an assessment of what we're ready to discuss, and if you think it's going to carry us through the full day or not.
Good morning, Your Honor. Simone
Morning.
Hudson for the state. Given the instructions that we received on Wednesday, we're working through reducing the wiretap. We're working through the research on the case law that's due on Monday.
Okay.
But we are ready to go through the exhibits for the remaining
Okay.
witnesses from 61 all the way to the end. I believe
Okay.
that Dropbox was served approximately 2 weeks ago. I'll pull up the exact date in which it was served. And so we're ready to move forward. I don't know if that will carry us through the entirety of the
Why were they allowed to have a Dropbox served 2 weeks ago? Shouldn't everything already been
day, but it
served?
is about 40 something witnesses
Okay.
that we could go
All
through.
right. And on the defense side, anybody have anything in particular that you're thinking today would be a good day to discuss?
You know, myself and Attorney Steele talked about this last night, and the only thing that we were thinking about was the wiretap, but it sounds like we're gonna wait for the state to try to pare it down before we tackle that. So I think that's all we have.
Okay.
Did I miss some
Travel court is
important
open.
part of yesterday? Okay. At roughly what time was that? I need to know approximately when that was.
Gordon Phoenix video.
Okay,
All right.
let's continue.
And then Bernie. Yeah, we've talked about him already. And then when we turn to the next page, page 12. This is one of those subsequent allegedly intrinsic acts, and I know I ruled on 2. and
Just at the end.
With-
Okay, we are really close to the end.
held ruling on 2, yeah. And this is, I think, one of the ones that I ruled out. It is, so we can eliminate that witness if that's all they're testifying to, right? I don't know, I'm on page 12, witnesses number 51 and 52.
Mr. Smith and
No, Timothy Brown, an investigator of Viverito.
Oh, okay. Yes, the court did. Yeah, so that, now, Mr.
Hang on. So 48 and 49 were Belknap and Flores, and we have moved on past them. We must be looking at a different document then.
Different numbers, I think. 48 for us is Deputy Timothy Brown, 49 for us is investigating real.
Okay, well, I don't know how that happened. I've got either an earlier or a later version. I don't know. What does yours say? Okay, well. What is the last witness number y'all have on yours?
Last one we have on ours is witness 105. That's Lieutenant Lynch.
Okay, so you know what? I remember you saying at some point, I've added 2 witnesses, so it's different, and maybe y'all are just looking at a different one, but the 2 witnesses, obviously, we just maybe. So you have 48 as who?
48 is Deputy Timothy Brown.
Okay, and I have that as 51, so somewhere above that are 2 witnesses who, I don't know, do you remember the 2 witnesses you added in?
So she added in 2 witnesses that nobody knows about.
Okay, so how about this? Going up from Belknap, I've got Henderson, Kornbacher, Stanley, Coppage. Y'all just tell me when you, yes, okay. When you hear one that you don't have, let me know. The AT&T custodian of records, Greer, Francis, Suk, Jenkins, Maynard, Hines, Russell, Latners, Viverito and Sprinkle, Lee, Hogan, Uden or Mitchell, Smith, Holmes, Latners, Underwood, Kilgore.
Maybe our issue is, so like Latners.
Yeah. Oh, there's no number for it. No. Okay, Munson, Arnold, Dennis, Jenkins, Hill, Battle, Turner, Pitts, Bell, Latners, Smith, Sanders, LeDuc or LeDuc.
Yeah.
What's on here is Zappa, that's really Appa. Reed, Voss and Weitzel, Bernie, T-Mobile, Sprint, Verizon, Sprinkle, Morton. Okay. The two, okay,
Oh, yeah, we had to add those because
Mr.
there was
Solve.
no stipulation, so we did
Okay.
have to add those. two.
okay. She just wanted to rub it in that y'all will not stipulate to the
I would never.
phone record
Never.
being a phone record. Okay.
I just realized, thanks to Arian the vegetarian, who is 30 minutes behind, Norwegian black metal. My ex-favorite band was Buddhism. Praise the Lord that relationship never worked out. And I was reminded, here's an idea. We are coming up on Halloween. Wouldn't the Norwegian black metal murders be a good Halloween stream? Wouldn't it? I think so. I just, yeah, Halloween.
All right. So anyway, back to Timothy Brown and Viverito on that issue. We can strike those two witnesses because that evidence is not coming in.
That is correct. Timothy Brown and
Wait, you had those listed in the indictment? Why does this say? So when I'm looking back at that, you've got like the counts and the acts right above those two people. You have counts 44 through 46, acts 169 and 170. Y'all had those in the indictment? How could you have done that?
Judge, I'm just one second. I'm going back where we are to.
Oh, what? So things that are clearly out were still in the indictment?
Yeah.
Serious?
So the indictment, let me look at my indictment. Let me sure.
Wow. Wow. Yes, explain, Ms. Love.
Oh, okay, so Judge, as it
these are
relates to,
in the
these are in the, right.
Okay,
the
so this
indictment
is
came out.
different than
Right, then the
the
other,
other
yes.
things that were subsequent entries.
And that's not me. So Judge, does the awareness of similar acts having been
I mean, maybe.
committed?
Maybe. Okay. So I'm sorry, those are obviously not out because those are indicted. And let me think about
What?
how similar that's pretty similar. I might revisit that ruling.
Thank you.
What? She,
I'm
okay.
not sure y'all made that argument at the time we were talking about it before.
So judge ruled something out. Then they discovered it's in the indictment. So not even the prosecutors knows what's in the indictment. And now this judge may have to revisit it because it is a
Alright.
similar act.
What do you say we break for the day, y'all?
I'm okay with that.
I say we break for the day. All right, and do we have any word? Okay. All right, so we will reconvene at 9 tomorrow and hopefully
Okay. Then now we can get
Um,
to today.
I know I challenged the jail call of Mr. And by the way, good morning, Your Honor. Good morning, everyone. Arnold on January 10th, 2015. And there's some, I believe, on the next day that the state may seek to admit. And a lot of it is, in my opinion, irrelevant. I don't know if we're going to listen to those calls for this honorable court to pare down or if the state and I should get together. But there's a lot of talk about food and girls and things like that. In addition, and I'm not saying, you were interested and I didn't say anything about Miss Morton being supposedly at the Texaco on the recording, and you said, oh, that may be enough for a conspiracy. I don't believe it is. I'd like to talk about that. But if you admit that, does your honorable court understand OCGA 24-1-106? So if that recording comes in, well, then I'm asking for guidance. So if that recording comes in, and if Miss Morton is not a witness, the state spoke with her, they put it before a grand jury, and they had a court reporter, and they did audio recordings with her at her probation officer's office. And under the rule of completeness, it is, you know, on that recording, it may be something that the state thinks is interesting to the jury, but it would be totally misleading if they're saying Mr. Williams is at that McDonald's. So my point is, another recording, another transcript, sworn testimony for this uncalled witness, I would seek to introduce through cross-examination of Mr. Sprinkle. He was at both of those places, and I believe that I would be able to get it in under 24-1-106. So I say that just because that's another issue if you want to do that.
Okay, so the other recording is an entirely different time?
Date, time, location, absolutely. And there's two. Like I said, one's grand jury, sworn testimony, and one's probation officer.
So my understanding of 106 is that it's if a part of one recording comes in, then in fairness, if the other party seeks to introduce the redacted or unintroduced part of the same recording in order for it to give a complete picture, that can occur. But I don't know that that means an entirely separate recording from an entirely separate date with entirely separate people communicating. So if you have law that indicates that, then I'll consider that.
So it's OCGA 24-1-106, I'm quoting, when a writing or recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing recorded statement, which in fairness should be considered contemporaneously.
All right.
So if I'm reading that wrong, I apologize.
If
But
those are the words, then you might have a good argument.
okay, I just want to bring that up since you're
Okay.
asking for issues.
All right. And is the state, I haven't heard the contents of that phone call yet anyway.
You're right. I think that we can discuss with Mr. Steele the parts that he's discussing. I believe that we can come to an agreement on what is not, the parts that are not relevant in that phone call. And if we can't come to an agreement, we can bring it to the court. But I think it's something that we can.
Okay,
deal
well, I don't
with.
know that his objection is simply relevance. I think he has a relevance objection to parts of it, but he's saying other parts of it, if there is something potentially misleading and there are other recordings that establish, that, it actually mean what it sounds like it means, then he would seek to introduce those other things that would clarify that.
Yeah, so my understanding, if it's the call that I'm thinking of, and if it's a call that was discussed yesterday, and I would need to listen to it again, I believe there's an inference as to Mr. Kendrick. I believe that in that call, and if it's the same call, and I'll need to just confirm that Mr. Bradford or Mr. Arnold calls Mr. Bradford while he's in custody. And at a portion, Mr. Bradford is with Bushi. Mr. Arnold asked Mr. Bradford, where is Yak? And Mr. Arnold responds, we're waiting for him. Mr. Bradford or Bushi, Ms. Morton, says, we're waiting for him. And they were talking about Yak Gotti. So I don't know. I will need to listen again and see if there's any other reference to Mr. Williams, and I will listen again to make sure. But my understanding is, and if this is the call that that was discussed yesterday,
Yeah.
then I need to listen again and see if there's a reference to Mr. Williams and being at the McDonald's, because my understanding is of the call is a little different, which is the only
Okay,
reference
well,
is Mr.
Then y'all just
Kendrick.
take another listen to it and get together on that.
Yes, Your Honor.
All right, and y'all can present if you resolve, great. If not, we'll present whatever the issue is after y'all both had an opportunity to listen to that. And if necessary, whatever part of the grand jury recording might then be relevant.
And excuse me, Your Honor, and I apologize, since I wasn't here yesterday. Are we still litigating whether that call comes in?
Yes, we haven't made any kind of determination about that.
Okay,
In fact, Mr. Howell, I think, asked that we hold off until you were present. So we just sort of, mapped out broadly what the issues might be, but we haven't listened to the call or made any kind of
Okay.
determinations about it.
thank you,
And
Honor.
it sounds like we'll hold off on that for a little while anyway, and it may or may not end up being necessary to litigate anything about it.
Thank you.
Okay. All right, so do we think, I guess the Dropbox with the evidence is on witnesses 31 through 60 is that going to track sort of this witness chart that we were going through yesterday?
It should be, Your Honor. I thought, if my memory served me correctly, that we finished up to 60. We had
I
completed
thought we
60.
had two.
We did. We completed 60 and we were at the
Yeah,
final group.
yes.
Yes, Your Honor.
Okay, so, all right, so we were kind of using this chart yesterday. So to determine, okay, are there things that we need to litigate? So if we
Yes,
want
Your
to
Honor.
just continue along with that, and then if there are things we need to litigate, then we'll jump to that Dropbox link and pull up that evidence. Is that the suggestion?
Yes, Your Honor. And I'm searching to see the date that we sent the Dropbox link so everyone can find it.
I think it's August 8th. No, I'm sorry. That's the
No.
one-
Took a bit too long to get to
Yeah, I think
today.
it might be August 27th, but I just want to. If it's not. Let me make sure.
And the panel show starts in 7 minutes.
Okay, I don't think that's the right one. Your Honor,
What I have is
Evanger videos is what the reline is? Is that what you said?
of course you don't.
Oh, yeah, she was saying she didn't think it was the right one either.
Skipping ahead. There's a lot of silence.
Need it. I can't find it. Need it. I can't find the email, but I'm just going to resend the link right now.
Hey, NJB.
Yeah, if you don't mind.
Okay.
Ms. Hilton, it looks like it needs a password, and that wasn't in what you sent me just now.
Okay, hold on. Okay.
Because Ms. Persfield just forwarded what you sent. So I think we'll all need that as well.
All right. Hold on. My Dropbox link.
At least they have password protection now. They didn't the first time around back in late 2022.
Okay. I'm going to resend it. I found the email. The email was sent on the 30th. I believe the link will be in this email that I'm about to forward to everyone.
And the password.
And the password.
Okay. All right, everybody's got to get a different email that'll have the password also.
So for a good 10 minutes, they have been trying to get into a Dropbox.
So everybody in there now?
Now you in the chat who, oh, look at that. John Mack! You remember? Yay! That brings us to 34 members today. Yay! Now you also have access to members-only content, members-only emojis on YouTube, and my Discord. The link is in the community section. Thank you so much. Thank you so much, John Mac. Yeah, they are still trying to get into Dropbox.
Yeah.
Now, for you folks, did anything of interest happen today? You who have already seen it? I don't think so, because I need to start that panel show stream in 3 minutes. I also need to visit the big boys room, because it's Friday evening here and I'm having a beer. Factual Lie says no. Martina, nothing, Nick, nothing at all. All right, I will post the link to the live on the panel show in the chat.
Okay.
Hold on.
All right, so number 52 is Miss N.Starow. She's going to be the records custodian for the Instagram records for a couple of the co-defendants and issues we need to litigate with her.
And you're right, I'll say 52 and 53, we already litigated. And the reason why it's in this folder is to be consistent with this document. So we looked at Sergeant Matthew John Pierre's folder
Okay, great.
as well as N.Starow's.
So everything that is left here is that Dropbox. Yeah. All right. 2 minutes until the panel show. Now, folks, it is pinned on the top of the chat, because just in case the redirect doesn't work, just in case. And yeah, thank you all for showing up. Thank you for allowing me to try to translate what's going on for you guys. Thank you so much for the memberships. And 34 today, that is an amazing number. We are currently at, let's see here. Dun, dun, dun. 43 subscribers away from 10K. Let's see if we find those 43 in the panel show. But thank you again, and see you in a minute and a half, I guess, on the panel show. All the usual suspects are invited. Kat should show up. Infamous Sylvia might be late. Kayla is always there. And maybe a couple of more. I don't know yet. But it will be us talking about what happened this week. Or trying to talk about what happened this week in the Young Thug trial. Then we might also talk about the latest in the Fonnie Willis debacle. All right? I will see you over there in a minute and a half. All right. Bye-bye.